think we'll have to give your opponent 5 minutes at the end of the day.
My Lords, can you take out the order? I want very briefly to show you how it works and what costs are involved. You'll have seen that we say in our case there are 5 different classes, 4 for the ordinary order, and by that I mean one unlike this one where it's not contested. But I can show you how a blocking order works by looking at this order, which is in the 3rd cardboard tab, the first part of the appendix. So it's page 262 of the electronic bundle. And the operative parts start on 263. And the key aspects are the requirement to block the target websites. That's paragraph 1. You see that at the top of page 263. And the detail of what must be done to comply with paragraph 1 is set out in paragraph 2. And in essence, it refers to Schedule 2, which has different technical means to be adopted by different ISPs. And as I think my Lords understand, the detail is negotiated separately with each ISP, tailored to their equipment and capabilities. Paragraph 1 also covers implementing new IP addresses or URLs subsequently notified to the ISPs. So what happens there, as a practical matter, if the website moves, they're notified of the change, they then have to block the new location on the internet. And the monitoring required to do that, to identify the new locations, is undertaken by the rights holders. And that is part of a broader monitoring required by the orders, all on the part of the rights holders, and you see more of it in paragraph 3 on 264. That paragraph is concerned with notification of changes to the ISPs in respect of IP addresses or URLs already blocked. You needn't worry about the detail. The common theme through those 3 paragraphs are changes that may occur which mean that a lower level of blocking is appropriate. Things like the website ceases to be at that site at all, or there's a change such that there's a third-party lawful website that becomes part of the picture. So all of paragraph 3 is monitoring of changes that can happen, and we have to do the monitoring to see when they happen so that we can notify. And so we have an obligation to monitor and notify under paragraphs 1 or 3, and you see in paragraph 4 that notification can happen under either of those paragraphs, and it says how we're supposed to do it. And in particular, paragraph 4b shows that the rights holders must send the information under both paragraph 1 or 3 in an electronic machine-readable form to be agreed with each of them, and on a timetable to be agreed with them. So in essence, we have to give it to them on a convenient timetable to them and in a way that they can accept it straight into their systems. That's why we say it can and should be efficiently automated. Another point to draw attention to is up at the top of 264, expressly it says that I'm looking at paragraph C, the respondents are wholly reliant upon the applicants. So the rights holders must do the monitoring, and the respondents, the ISPs, have no obligation in terms of verification and so forth under the order. Go forward to paragraph 11. So that's page 266. That's what Mr. Justice Arnold termed the sunset clause, and that's the fact that the order comes to an end after 2 years unless it's renewed. That's the basic structure of how they work. Now, as to the costs that are involved, the first category of costs are the costs of securing the order, putting together the materials, making the application, and filing a skeleton argument. The normal way that's done is without a hearing, but the applicant, i.e. the rights holder, has to do all of that. And so they bear the costs. In this case, that's given effect to, in paragraph 13 of the order, by the exclusion of those early costs, i.e. everything up to the date of the issue and the service of the application. So in this case, that's given effect to by that exclusion, but in the ordinary case, it's given to effect to by there being no order as to costs.
Sorry, what is ordinary? Paragraph 13 is not ordinary.
Yeah, it's excluding it. But what happened in this case, because there was a big spat about...
Oh, it's because the respondents
Yeah.
resisted vigorously, so
Yeah.
that's exceptional order.
Exactly.
All costs before service are borne by the right holder.
Exactly.
In this particular case, because an award was made against the ISP, the costs thereafter are reflected in balance.
Exactly. And what I'm trying to say, perhaps rather inelegantly, is that that aspect is reflected in this order in a rather unusual way by the exclusion.
I mean, if there were no opposition, then there'd be no cost order.
Exactly. Usually there's a no order as to costs, and that's reflected in that aspect. So that's the securing the application. Next is the monitoring costs. They're something which we don't recover either, and you've seen the obligation on us to do that. Monitoring is the responsibility of the right holder. The reality is it has to engage a specialist to do it and to pay for it. So that category, monitoring costs, all borne by the right holder. And you've seen the paragraph that specifically says no obligation on the ISPs to do any monitoring. The actual implementation is dealt with in paragraph 12, where they have to separately bear their costs of complying with the order. That actually covers two categories. The first is the cost of the infrastructure that's used, and that was an item, as I think I've already said this morning, in respect of which very large sums had been sought in the courts below, and in fact the same had been tried in the first Section 97A case, News Bin 2, and that argument's been dropped before your lordships. Although I think they say they reserve the right to ask for it later. The fourth category falls within those implementation costs of that paragraph, and they are any additional, i.e. marginal costs that the ISP incurs in complying with the order and the updates that come.
Sorry, which paragraph is this?
Well, it's all within paragraph 12.
Yes, I see.
Saying to my lords that that actually covers two things. The fight before the judge and the Court of Appeal broke down implementation costs into what we're now calling implementation costs and capital.
Okay.
But they're both dealt with there. And as the Statement of Facts and Issues makes clear, it's paragraph 45, there's a dispute between the parties as to the costs that are to be regarded as attributable to the orders. And that's because, as I've said to my lords and shown you, it should be capable of being carried out largely in an automated way, as indeed other categories of blocking are. But the reality is what my friend is here fighting about is that they want the right to verify what we're doing. And you see that very clearly in the substance of paragraph 199 of their case. And that's why earlier on this morning I said it's really about monitoring our monitoring. You see what this is about. So it's page 121. They want the incentive to invest in verification, testing and monitoring of website blocking.
Paragraph 199 of their case.
Their case, I do.
That's 121.
121 page of the bundle, top of the page. What they really want is the incentive to invest in verification, testing, monitoring of website blocking on a day-to-day basis in order to prevent over-blocking. This fight's about. Now, my lords, the judge, in the exercise of his discretion, decided that the responsibility and therefore the cost burden should fall in the way that I've shown you. And there is a significant amount of that burden, in fact, the lion's share, falling on the rights holders. In terms of the actual numbers, you will understand that the cost to the right holder per website is not cheap. Costs of securing the order and the necessary monitoring over, say, the 2-year period of a life, you're looking at over £20,000 per website. And that's an approximate figure one gets by totting up the numbers in the schedule to the facts and issues on page 60 of the core bundle. Final point I want you to note, if I may, on the order, is that paragraph 9, so I'm back in the order in part 1 of the appendix, page 266. Paragraph 9 provided for a specific liberty to apply, including as to costs, consequences for the parties and effectiveness. I think you may have seen that the judge left open the making of different cost orders in different applications later on, but he also did it specifically in this case. Particularly given that some of the arguments that were run are in effect floodgates arguments from the ISPs. The judge's view and assessment was that these orders would be used sparingly, something we say has been borne out. But he left that liberty to apply there in case things turned out in a way which was unjust or in a way that couldn't be foreseen or not in the way he saw in any event. And the reason I'm drawing this to my Lord's attention is that no application has ever been made under that paragraph.
It'd have to be a material change of circumstance.
Indeed. And so, for instance, the assessment that the orders would be used sparingly, if it turned out that they weren't, that would have been a material change of circumstance. And there has been no application because there could be no suggestion that that is indeed turned out to be the case. So I've told you about 4 categories of cost, and that the fight's really about that 4th one, the monitoring costs. Finally, in this case, there is a 5th category of cost, the substantial fight over the argument, the legal argument on jurisdiction. And the judge there specifically exercised his discretion because there was all-out opposition, and we'll come to it. There's a very short judgment where he specifically addresses it, and our submission is there can be no question of interfering in the exercise of that discretion when you look at it. He took into account the fact that they were not tortfeasors, but he took into account a whole load of other factors as to the way the case had been conducted, and concluded that the losing party, which was them, should pay. There's a peculiarity about that, because I'm not sure it's actually within the permission to appeal in any event, but also it's an order against each of the ISPs jointly and severally. So I assume that what's sought is an order that these particular appellants are excluded from it. There can be no basis for setting aside the order that the ISPs that don't appeal pay the costs. So I assume that that's what's sought. And I also, as I understand it, understand that it's not a suggestion that the costs of the Court of Appeal should be upset either. But it's not entirely clear. Now, having quickly been through the order and identified what the fight is actually about as a practical matter, can we move to the key part of the case, which is the EU directives, because that's really the answer to everything. And as I've already foreshadowed, they recognise the special place of intermediaries in a way that has been done in other contexts, as I've said. I'm going to be looking at a trio of directives that my friend has taken you to. They're known by lawyers as short titles. Firstly, the e-commerce directive, the Information Society Directive, which is a not terribly helpful name. It's about copyright broadly, but not only. And the third one is the Enforcement Directive. And therein, the First Authorities Bundle 1A at tabs 4, 5 and 6. And I'm going to take you through them in some detail. And the reason I'm going to take you through all of them or each of them, is because they are the foundation of the jurisdiction in both Section 97A and trademark cases under Section 37. And the next topic is to show you why that's so. And it's important to have regard to them, their overall structure and purpose. And that is what Mr. Justice Arnold did and Mr. Lord Justice Kitchen. And one of the things I say to my lords is that a big criticism that I have of my friend's approach is that she fails to have sufficient regard to this important matter. The first two in time, that's the e-commerce directive and the information society directive, were adopted at around the same time, not exactly the same time, around the same time. And it's important to bear that in mind because my friend tried to make some point about the e-commerce directive being 4 years before the enforcement directive. But just so you see the bigger picture, what happened was the first two were adopted together and clearly intending to be part of a calibrated package, which included the right to claim injunctions against intermediaries in a copyright case, and then that right was extended in the enforcement directive. That's the big picture. And so let me make good the point about the first two intended to be adopted at around the same, or in the same time frame, sorry. We can see that by the fact that they cross-refer to each other and say as much in the recitals. So if you go first of all to tab 6, this is the Information Society Directive. You see it's formally adopted about 11 months after the e-commerce directive. But if you go to 486 and recital 16.
Recital?
Page 486, recital 16. And that reference there, the Directive 2031 EC, is the e-commerce directive. And as the beginning of this directive makes clear, it addresses liability for copyright and related rights in a network environment, but not just that, other areas such as defamation, trademark infringement, and misleading advertisements, which incidentally can also be a trademark infringement if they refer to a trademark. And you see halfway through the recital the reference to the e-commerce directive clarifying and harmonising various legal issues. That is a reference in my submission to the probability in some cases, possibility in others of liability on the part of the intermediaries that I've referred to. And you see about 2/3 of the way down saying that this directive, i.e. the Information Society Directive, should be implemented within a timescale similar to that for the implementation of the directive on e-commerce, since it's intended to be, that directive is intended to provide a harmonised framework for the principles and provisions relevant to important parts of this directive. So they're coming as a package.
Well, merely because one refers to the other doesn't mean say that they are a package, does it? I mean, they might be 10 years apart, and that might still be the case.
No, it's more than that, my lord, because it's talking about the need to implement in a similar timescale.
Yes,
It's much more than just cross-referring to something which is relevant that's happened in the past.
Well, yes, but I mean, that's always a possibility, even if this recital appears in the later of the two.
I'm going to show you the earlier one as well.
What?
I'll show you the earlier one, and there's a cross-reference
But I mean,
there.
you don't get the point that you're making out of a reference in the later one.
Not
You
only,
might get it out of an anticipatory reference in an earlier one.
well, maybe that's my fault. I've done them the wrong way around. But I'm going to show you the same thing in both.
Right.
But can I finish this directive first? Recital 4, if we go backwards. Just want to deal with the whole of this so you see the big picture. Recital 4, so that's page 485, emphasises a point I made a few moments ago as to the importance of copyright protection to foster substantial investment in creative process, and the second half of it explains specifically how that is of importance to society, both in industrial and the cultural sectors. You see that? And that point is amplified when you go forward to recitals 9 to 12 on page 486. You see express mention of copyright and related right protection being in the interest of the public at large at the end of recital 9, and the cultural importance is singled out and referred to in recital 12.
Are you saying that because there is a public interest in it, so to speak, everybody, including ISPs, must put their shoulder to the wheel?
Yes.
Yes. I mean, there's a problem about that, isn't it? What we're actually arguing about in this appeal is money.
Yes.
100% of the financial benefit of these orders goes to the rights holders. So,
Except that's right, actually.
well, all right, maybe not 100%, but substantially, all of it does go to the rights holders. I can see that there may be a knock-on benefit for the suers. But why should the cost of improving somebody's financial position in relation to that person's rights be paid for by somebody else?
Well, you can look at it the other way round as well, and one of the points that I was going to show you, in fact, let's do it now. I think it's tab 70, the Irish case, because they explain what happens if the ISPs say they're not going to. So I'm jumping ahead a bit. Let me take out tab 70 in Authorities Volume 4. And part of the answer is, before we look at the detail, I'm actually going to turn up 1880 and look at that page and over into 1881. But let me try and summarise the answer. A big part of the picture that is not part of what you've just put to me is that if they don't do it, or if they say, I'm only going to do it if you pay me, is that what happens is that their service becomes much more attractive and is used more. They make more money. Their service is a central act in the act of infringement. And they, because of the threshold conditions, never the subject of an injunction until they have specific knowledge. And what you're looking at on the other side of the coin is that they are saying they're entitled to make money out of providing a service which they know is specifically being used to damage intellectual property rights holders, and they ought not to do nothing about it. They ought to do nothing about it. Or at least it shouldn't cost them any money.
Well, there are two distinct points here. Not have merit, but one is who should pay for a commercial benefit to the rights holders? And the other is it in some broad sense the ISP's own problem because they are the means by which these infringements are being made possible, facilitated? Now, I'm not sure, those are not really the same point. They're distinct points, aren't they?
They're related. They're certainly related. And
there are certainly both reasons why, which you pray and aid. Yes. But surely we are concerned here with the incidence of legal risks. And the incidence of legal risks must depend on the directives. And the directives essentially exonerate them from responsibility. You appear to be arguing for some kind of non-legal responsibility. Well, you say, well, they're all in it, even if they're not legally responsible. Why aren't we simply concerned with the distribution of legal risks, which is implicit in the directives?
well, even if that was so, I've got more to show you in the directives. There are recitals in there that show that they have a duty to act. And so, I mean, I'm afraid it's one of those things where there's a lot to go through. There is more to it. But to answer my Lord's question, am I saying that there's an obligation on them because there's a wider public interest? In part I am, but not just because of that. I'm saying that that is recognised in the EU directives.
But the obligation arises on them being given notice, and an order is then going to be sought, and they're going to stop. So where is this profiting? Do you say it relates to the period before they get notice, when unwittingly people may have been using their facilities to access counterfeiting sites?
No, I say that what you should properly be comparing is the situation whereby they would say, I'm not going to do it unless you pay me, and then they would be profiting.
They don't have that option. They can't do it before they get notice, because they're not allowed to monitor. When they get notice, they're going to be subject to an injunction. What they can't do is say, I'm not going to comply with an injunction unless you pay me, unless that's a term of the injunction itself.
But that's the argument. Should it be?
Yes.
That's the argument. And so
It's not. If the position is that the injunction requires them, entitles them to an indemnity, that's because the court so orders. It's not an election on their part.
I put that badly then. The point is to say that that ought to be the regime. I shouldn't have to do anything unless I'm paid. That is the order. That is the regime that should be applied. You're quite right. I'm not suggesting that there's an option, but they're arguing for that as the way in which the order should work. Can I just show you what's said about how it would work otherwise in the Irish case? And really what you should look at in my submission is actually an extract from the judgment below, which was approved. And so if you look at 1880 and look at the paragraph, this argument. So that's 6 or 8 lines down. And the argument is that they are providing a service. Sorry, it's tab 70, page 1880, my lord. The argument is that the defendant benefits from the enhancement of the service that he's providing, its attractiveness. He's able to do something about it because they all have terms saying you can't use it for intellectual property right infringements, but they refuse to do so.
Well, what is that? The defendant has the contractual right to do something about this, in respect of whom, before it has notice, does it have that contractual right, and in respect of whom, before it has notice, is it simply refusing to exercise the right?
The contractual rights that arise in these cases, my lord, are when you sign up to an ISP to be a consumer there, you promise not to use it for unlawful purposes. So they have a right to stop you using it.
But since they don't monitor the content, how is Mr. Justice Cregan right to say that they're simply refusing to exercise their contractual right? Before they got notice, they don't know.
You couldn't invoke the right. You can't invoke the right until you do that.
No, I don't think it's addressing that. It's talking about an argument that they shouldn't have to do anything.
Well,
Talking about an argument.
well, that begs the question if they're entitled to.
The very last
he's not suggesting that they're refusing to obey an injunction.
No, absolutely not. No, absolutely, it's not that at all.
When you're saying that they are arguing for a regime in which there wouldn't be an order without their paying, so that they would effectively be given a right to refuse to do it.
Yes, and don't forget, this was a case where they didn't have the systems either, so there was a broader argument about paying for the capital cost.
But I mean, you seem to be alliing two different. I mean, these obligations exist on different planes. There are a number of rights arising out of general principles of law and contracts and so on, and there are rights and obligations arising out of the order. All that we're concerned with is what regime the courts should impose as terms of their order. I'm not sure that it's really fair to say that because there are certain terms on which an injunction would be available, which might, I suppose, be unacceptable to the rights holders, it follows that it's a free-for-all as far as the defendants are concerned.
Well, what they are arguing...
Even without Articles 12 to 14 of the e-commerce directive, but a fortiori with them.
But what they're arguing is for, in effect, an argument that this really hasn't got anything to do with us. And what this reasoning shows, and I'm going to show you more in the directives, is that they do have a role to play in the resolution of the problem. And that's what we see reflected in the French court decision that I mentioned this morning. And the role to play is not simply to obey an injunction that they're paid to comply with. The role includes recognition that there may be some cost to them, and it is part of a wider picture where they're running a business which is being used, the service is being used to infringe, and it's only possible because of the EU package that swept away the uncertainties that may have impacted upon them in different areas as well. So it's a broader picture.
If the court were to refuse an injunction on the ground that the rights owner was not willing to undertake to pay the costs, and the infringements therefore continued unabated, let us suppose that Justice Cregan's characterisation here that they refused to do anything about it was correct. Now, having regard to Articles 12 to 14 of the e-commerce directive, are you submitting that that would be unlawful as an attitude for the ISPs to take, or simply that it would be deplorable?
Let me just make sure I've absorbed everything you're saying. The court refused an injunction.
Let us suppose that the court refused an injunction because the rights holder was not willing to undertake to reimburse the costs of implementation.
Yes.
Right? So we're then in a situation that Mr. Justice Cregan describes here. The defendant has the contractual right to do something, but it simply refuses to do so. Now, are you submitting that by refusing to do it, the defendant would be acting unlawfully, or are you simply saying that in some wider sense it would be an immoral or unfortunate thing for that?
Well, he would, let me be absolutely clear, he wouldn't be acting unlawfully.
They wouldn't be, no.
But what my argument is that the court ought not to have refused it on that basis, because when you look at the overall structure and you look at reasoning like this about the role to play, what you really have is an acceptance that they are in a special position, they have privileges which, if there is no injunction, mean that they're making profit out of the infringement. That is the guts of that. That is the guts of that paragraph. If there's no injunction and it carries on, their services become much more attractive, they're making profit out of that, and actually they have a role to play to combat it.
But not a role that you can say represents a legal obligation.
In the scenario that you put to me, I agree. But the argument is about whether the court should be granting or withholding injunctions with that requirement. And so I deploy the argument directed to what the court should or shouldn't be doing. Absolutely, if the court decides the other way, then what they're doing is taking advantage of that in a perfectly lawful way. But that's kind of begs the question. And the point is that when you stand back and look at it, and I'm only just beginning on the recitals, actually. I've kind of
Yes, we don't want to
Delay you too much.
delay you too much, but
I mean, you say it's very important that we see the directives as giving rise to the core of your case.
Yes, indeed, but also the reasoning in all these other courts as well.
Well, I think we've got that point, but I'm still puzzled by the relevance of the profits they might make, but for an injunction, which the injunction will stop them from making, on the question who should bear the costs of complying with the injunction. But I mean, if they'd made the profits, maybe they should devote some of them to complying with the injunction. But by definition, the injunction will prevent them making the profits.
I absolutely accept that. The injunction would stop them if the court orders it on the right terms. And really the argument is it fair? Is it fair
No.
for somebody who is making money to say, okay, I will do something about it, but I'm not going to contribute anything in terms of resources to it?
I mean, it seems to me your argument ultimately comes back to the fact that probably they must in the past have been making some money out of these illegal or counterfeiting sites before they were drawn to their attention. So they should chip in a bit for the common weal.
Well, it's more than that. It's that they are continuing to make money after there is injunctive relief available.
Not from the counterfeiting sites.
No, exactly not.
No.
But as from the ability to run this business because of the package as a whole.
Yes, but, well, when we say the package as a whole, the rest of the business is surely separate, isn't it? It's legitimate business.
No,
The package as a whole was referring to the safe havens, I think.
Exactly. It's the whole thing. And let me show you that there's a balance involved by the next recital I wanted to take you to. It's recital 22. I do need to
Yes, speed up.
push on. 22, so I'm on 487. It draws attention to the need not to support dissemination of culture, i.e. encouraging the ability of the internet to disseminate works and information by tolerating illegal counterfeit or pirate works. So this is a reference to the balance that needs to be struck between the two competing aims, providing for a proper operation of the internet and the need to stop, i.e. not to tolerate pirate and counterfeit works. The other key recitals in this particular directive are 58 and 59 on page 490. Recital 58 requires sanctions and remedies to be effective, proportionate and dissuasive. And 59 is important because it is the recital that explains the rationale for the right for injunctions against intermediaries. And you see the statement is that in a digital environment in particular, so that's online, services of an intermediary may increasingly be used for infringing activities. The focus is on the services are being used for infringing activities. It goes on, importantly, to say that in many such cases, the intermediary is best placed to bring the infringing activities to an end. So the point is that its services are actually being used to infringe. And so it says the rights holders should be able to apply for an injunction who carries the third party's infringement on a network. And the recital makes it clear that this should be so even if the act of the intermediary are exempted under Article 5, and it provides that the conditions and modalities should be left to national law, as we've seen.
That's why you have a right to get an injunction, notwithstanding that you don't have an obligation apart from the injunction.
Exactly.
Those are the two things you...
There are two things. And
It's all dependent on the injunction.
well, what they're doing is bringing in the right to require the service provider to stop their service continuing to be used to infringe. Article 5, just so you see it, is another one of those immunities, but it's not in the e-commerce directive because it's specific to copyright type rights, and it's to do with the temporary act of reproduction. And
This is caching, is it? Is this caching?
That's one of, yes, that's part of it. But you see that the act of reproduction or the reproduction right is on the left-hand side, and there is 5 different types of acts that it applies to, including performance rights and then all sorts of other things which under English law are copyright. And one of the purposes in which you can fall within that exception is the network, transmission in a network between third parties by an intermediary. So that's one of the exceptions is in this, this directive. And you know, I think, that the actual effective paragraph is Article 8.3, which I don't need to take you to because you've looked at that this morning with my friend. Now, the directive referred to earlier was the e-commerce directive, which I want to take you to at tab 4, if I may. Recital 7 and 8 on page 460 of the bundle. You see from that it's concerned with ensuring legal certainty, providing a clear legal framework to cover certain aspects of e-commerce. So again, it's concerned with the potential problems that people providing these services faced. Recital 40 on page 464 recognises, about 6 lines down, that service providers have a duty to act under certain circumstances to prevent or stop illegal activities. So I'm on page 464, left-hand side, about 6 or 8 sentences down. Service providers have a duty to act under certain circumstances with a view to preventing or stopping illegal activities. And it goes on.
When I did quite... how many lines down?
I beg your pardon, I didn't.
How many lines down?
Oh, about 6 or 8. It begins after a semicolon,
Yes,
service providers on the right-hand side. 6 lines down exactly.
That's reference to the procedures in this directive, is it?
Actually, it's a broader reference, my lord, but it does, for instance, when one sees the exclusions, mentions that they shouldn't affect the availability of injunctions against intermediaries. So, in substance, yes, I'll show you when, for instance, we go to Article... In fact, let's do it now. If you go to Article 12... (470), in fact, top of the page 471, you see subparagraph 3, just by way of example, talks about possibility of injunctions.
Apart from the directive.
Yes, but at the same time they were providing for them in the Information Society Directive.
So this is a recognition that there may be a right in national law to require a service provider to terminate or prevent an infringement, even if no such requirement arises under the directive itself.
Not just that, my lord, because as I promised you, the recital in this directive also recognises the Information Society Directive, which was a draft, if you look at recital 50. So it's recognising that that's coming as well, and you know that that was in there.
The proposed directive, yeah.
So that's why I say they cross-refer, and the exclusions, for instance, in paragraph 3 to Article 12, relate to that kind of injunction as well. Now, in recital 40, it says that they have a duty to act under certain circumstances, and it also goes on to say that the directive should constitute the appropriate basis for the development of rapid and reliable procedures for removing and disabling access to illegal information. And it goes on in the context of suggesting that some of the procedures could be voluntary. That is, it's in the interest of all parties involved in the provision of information society services, that's basically online intermediaries, to adopt and implement such procedures. So that's an acknowledgement in my submission of the wider interest in clearing away illegal material. It's an encouragement to the voluntary schemes that I referred to earlier. and in the context of a recital which is recognising that the service providers have a duty to act in some circumstances.
That's the circumstances where an injunction is, isn't it? Those are the rapid and reliable procedures in the next part of the sentence.
Well, in my submission, it's actually referring to a broader concept that certainly covers when an injunction is granted, but in the context of talking about voluntary schemes as well, it's talking about a broader concept of a duty where you volunteer to act to remove illegal material which is in the interests of all concerned.
Depends what you mean by illegal material. I think we were told that it wouldn't be open to an ISP to block a site without being the subject of an injunction.
Well, there's some debate about that for the reasons in particular that my Lord Reid pointed out. But what I do accept is that there is an additional concern for these particular intermediaries, not all, but for these in particular intermediaries, to make sure that they don't fall foul of that regulation. And so I don't actually criticise them for requiring a court order to make sure that there is no problem with that. What I do criticise is their argument that because they can require a court order, they ought to have a different cost regime to the ones that are doing it voluntarily.
Well, voluntarily doesn't exclude agreement as to instance of costs, does it? I mean, we don't know what people would have agreed voluntarily.
No, that's not true, my lord. We do know that the voluntary schemes, certainly the ones that we've been able to check, are all done without costs being incurred.
But if they're done in the general public interest, public pressure, governmental pressure to avoid children, for example.
No, I'm not talking about those. I'm talking about the specific takedown provisions that my friend accepted were done with no charge. So I'm talking about, for instance, if you've got a counterfeiting website and you want to get somebody to take it out of a listing, or you've got infringing material hosted on YouTube or things like that. All of those platform things that are taken down off of Twitter and Facebook, they're all done on a regime which is voluntary in that no court orders.
We do that for a variety of reputational or other reasons, but there is no duty to enter into a voluntary agreement on those terms. It's a matter of negotiation. Once you've entered into one, of course, there may be whatever duties the voluntary arrangement imposes.
I'm not sure it's a matter of negotiation because it's with the public generally. They offer those facilities voluntarily without charging.
By definition, a voluntarily assumed obligation is not an obligation you would be bound to assume.
I do understand that, and really at the heart of this is you've got to be careful about notions of duties in the broader sense of you've got an obligation really in the public interest to do something about that, even if it might not be a strict legal obligation, and duties that are put to me on the basis of there's a legal requirement that you must do this, either because the law provides it or the court has so ordered.
You're not suggesting the latter exists, it's the former.
Yes. My submission is put on the basis that what is being recognised in the directives is the former. So it's not simply the former on its own, but what is being recognised is the former.
I think Lord Reid had a question.
Well, it was simply, I wonder how much really we can take from the voluntary behaviour of the platforms, because Ms May showed us the legislation which requires them to take material down as soon as they become aware of it.
They're hosting.
Yeah. Yes,
They're not all
storing.
hosting. They're not all hosting. That's the point I tried to make to my lords earlier. Some of them are, say, take an obvious example like YouTube. That is a simple, straightforward hosting. But some of them are like Facebook with links or Google and so forth.
Search mechanisms are not hosting.
Exactly. It's broader than that. Now, Recital 47 provides for sorry, 45 says that, in effect, says that the limitations on liability do not affect the possibility of injunctions, and you've seen one of the operative provisions that gives effect to that. 47 provides there can be no monitoring obligation on the service provider of a general nature. And 50, which I've already jumped forward to, is the one where you see the cross-reference to the other directive, the Information Society Directive, and the requirement to implement in a similar timescale. Now, you've already seen the key articles in the directive, so I'm going to deal with them very quickly. They're Article 12, 13 and 14, and in fact 15, because that's an obligation or a provision that applies to all of the scenarios. One thing I would say is my friend suggested that Article 12 was the only thing that applied to people that are transmitting material. I don't think that's quite right. My submission is Article 12 and 13, because that's the caching as well. Article 14 is specific to hosting, and 15 basically covers everything and says there can be no general obligation to monitor. So, my lords, what we have is these two cross-referring directives doing several things. First of all, it's recognising the need for a framework giving legal certainty. Otherwise, the ability lawfully to operate the internet would have been in jeopardy. So it's recognising the special position of the intermediaries, first as regards the exemptions from liability, but it is also recognising that they sometimes have a duty to act to prevent or stop illegal activities, as recital 40 of the e-commerce directive says. It is also seeking to ensure that the effective dissemination of information and materials occurs or is facilitated, but not at the expense of tolerating counterfeit and pirate goods. And in my submission, the way it does that is to provide for a calibrated package. Exemptions from liability are provided. They're not to apply to injunctions against intermediaries, because they recognise that they are often best placed to stop the infringement. And so they should be available at this point to bring to an end infringements of copyright and related rights, but as you know, it was later extended to all intellectual property rights.
I mean, incidentally, I noticed recital 50 on page 465 gives you the link between this directive and the Information Society Directive.
Yes, indeed. If I didn't,
If you referred to that.
I think I did. Maybe I didn't make it clear enough.
No, I must have been reading something different.
Not at all. It's the thing I promised my Lord Sumption.
Yes.
It comes both ways round.
Pick that up.
And my Lord, we say the recognition that they're best placed to stop the infringement is not, it is a recognition that they are inevitable and essential actors in such infringing activities. What you get is a carefully balanced package as a whole, and it is just another manifestation of the recognition of the ISP's special position that we've already seen in the matters that I've mentioned too. Another thing that's really important is that the package includes valuable immunities from liability that, as we'll see shortly, in the words of Lord Justice Kitching, support and benefit the business of intermediaries. That's what these immunities do. Now, my lords, as you know, Article 8.3 was implemented in Section 97A. In fact, we often forget to mention that it was also implemented in section 191JA2, which is the equivalent section dealing with performers' property rights. So it's been
Or JA2 stands for?
section 191JA, sorry, 2 as in as well, not sub 2. So it's section 191JA, the wording's the same, and it's in the section of the Copyright Act that deals with performers' rights. But when it came to the enforcement directive, which came in about 3 years later, the government didn't seek to make specific provision. But what that directive did, which is the one I haven't shown you yet, is extend the requirement for EU member states to make injunctions available against intermediaries to all intellectual property rights. And so that's at tab 5. And it recognises that what it was doing was not changing the position for copyright. And that's recital 23 that my friend has already shown you on page 477. Recital 29 is worth looking at because it reflects what I say is recognised by the EU legislation, that industry as a whole should be playing some part. It says industry should take an active part in the fight against piracy and counterfeiting. Reflecting what I say is the broader importance to society than just to the individual rights holders whose rights are infringed in any specific instance. And as you know, the key effective provision is Article 11, second half, which extends the right of the injunction to be available against, in this case, trademark infringement websites. Now, my Lord, can I just stand back and explain what our case is? An important part of our case is the jurisdiction that's being exercised is to require an intermediary to stop its services from being used to infringe. That's unlike Norwich Pharmacal, where they just have to be mixed up some way. They are not the central actor. As I think I've already emphasised again and again, both in the copyright and the trademark context, that jurisdiction comes as part of this calibrated package that is directed to securing several aims. The ability to lawfully make the internet available, but the ability of rights holders to have their rights respected. Don't forget one of the things that I said to my lords very early on, that part of the big problem that rights holders face is that the internet allowed this kind of activity to go on a totally different scale to that which had gone before. But on the whole, the internet's been considered to be good for society, and the intermediaries given the special immunities so as to be able to operate it. Our submission is that part of that is to address the downside in the massive extent to which it enables infringement, and the responsibilities that come require industry to be taking an active part, and in specific, being more specific, what we saw in an earlier recital, the intermediaries being under a duty to act. To put it in a very pithy way, the intermediaries are profiting from the business, which, because of its nature, also requires policing. And once they have specific knowledge about instances where it requires policing, we say they shouldn't be in a position to argue before my lords that they will not police unless the entire cost of policing is reimbursed to them. And in effect, we see a similar sentiment reflected in Lord Justice Kitchen's judgment. And so now I'm looking at the core bundle. If you pick it up at paragraph 142 on page 245.
Your clients presumably sell on the internet?
I believe that's so. I haven't checked.
So, I mean, the same, couldn't it also be said, your clients profit from a business which involves use of the internet, requires policing, and they should cover the costs of policing?
I don't think our websites require policing. The problem is the unlawful.
Your websites are no good unless you can eliminate the infringing ones.
Well, they're less successful, certainly.
Yes.
Yes, I'm not. But that's not our services being policed, my lord. I mean,
No, but it's another services, the policing of which would be beneficial to your client.
Certainly the policing is of benefit to my client. That's why we apply for the orders. But what I'm saying is when you look and you stand back and you see that actually what we're talking about is somebody saying, I want to be able to provide this service, which will be the central thing through which infringement takes place. When I have specific knowledge of the infringement, I ought to be able to say, I'm not doing anything about it unless you pay me to. That's what.
Well, I think the way that the appellants would put it is, I'm going to do something about it, but I shouldn't have to pay for doing something about it.
Indeed, it's the same thing put the other way round.
Yeah.
I will do something about it if you pay, but not if you don't. Now, I
don't know that, is it open to them to say, I'm not going to do anything about it?
That's the kind of debate that I think I was in with Lord Sumption just a minute ago. Certainly not if the court orders it, but what we're arguing about is what the regime should be that applies. And so that's why I say that's what, in the effect of what they're saying. But if you look at paragraph 142 of Lord Justice Kitchen's judgment, the first point he makes is the point that I've perhaps banged on about too much, is that the injunction is against intermediaries whose services are being used by a third party to infringe intellectual property right. That's 142. And then if you look at 143 to 144, he's in effect making, in substance, the point I've just articulated about how these two articles, Article 8.3 and Article 11, must be seen as part of this larger scheme, which includes immunities for infringements, and those immunities, including the no obligation to monitor, support and benefit the business of intermediaries such as the ISPs. So I'm looking at the top of 246.
Are we in a slightly messy position? Because, I mean, your opponents have a simple proposition. Your proposition is a rather mixed one because you accept that you should bear quite a lot of the costs. Why aren't you arguing that the intermediaries should bear all the costs? They run these services which make possible this these counterfeiting sites. Why aren't they responsible for everything on your scenario?
Well, my two reasons that I wouldn't put my submission that highly. Firstly, what the judge has done is an exercise of discretion to portion the costs up in the way that he thought was just. And that is why I've showed my lords that a large part of it, the lion's share of it, falls on my clients in any event.
I think your submission is that he could perfectly properly have made the ISPs pay them off.
He certainly could have made them pay more of it, And that's what happened in Ireland, definitely. They didn't have the right system in place and they had to pay 80% of putting the system in place. What I certainly could have said, for instance, it would have been within the judge's discretion to say that the monitoring was something that they should have undertaken and paid somebody to do. He didn't. I don't challenge that. It's a discretion. And he's looked at it, and he's looked at these factors about the broader picture, the obligation and the balance. It is a balance that one's looking at. And you see that when you look in the CJEU cases. And he's decided that the way in which the fair balance is struck in this case, as a matter of discretion, is we pay the lion's share, but particularly the costs that we can't control and in fact dispute. That's why he hasn't had to decide this about the monitoring or monitoring, because our position is this ought to be automated in much the same way as the live blocking when they like that because it's football matches, or the other situations of the IWF, and as I understand it, even the family blocking, they just take the information and feed it in. We say it should be automated, but we don't have any control over this. And the judge, in his discretion, has said that the costs that you don't have any control over, you don't have to meet. They're not that great anyway.
Has the judge or anyone expressed a view as to the reasonableness of the actual costs which you're criticising, the actual monitoring costs? Because if the case was decided on the basis that the ISPs were just wasting a lot of money by fussing about whether you're identifying the right websites, that would be one thing, but I don't think it has been decided on that basis. Has anyone expressed a view?
Well, one thing that I do recall, and we could see if we can find it, is that the judge expressed a hope that the parties could talk about how it could be made more efficient.
Yes, because I mean, without the monitoring of the monitoring, or the order puts it all down to you, and it's a rather remarkable order because it means that a party to litigation can, on the face of it, identify websites and nominate them, and they will be blocked by court order.
No, you don't nominate a new website. It's the same website that moves or something changed. It's not.
Nominate a new
IP address. So if it's the same website that's gone somewhere,
I see.
And that's quite important.
Yes,
because there was a suggestion at some point that we kind of say anything can be ordered.
Because these websites can change their IP address or URL.
That's the great benefit of these orders, is that they're flexible to be able to react. If you block somewhere, an obvious thing they would do is move it somewhere, and you can trace where it's gone, and then say, the website's now here, please block this IP address. There's complications where they're at an IP address where there's lawful material as well, and that's part and parcel of paragraph 3.
Yes, that's reducing the scope of the order.
Yeah. It's adopting different technical measures depending upon how the website is located, or the URL, because it's not just an IP address. So the answer to my Lord Sumption is, certainly before the judge, I could have argued that a higher proportion should be shouldered by the ISPs. But it is a matter of discretion, and you will have seen that he left it open to be revisited if things didn't turn out in the way that he thought. That has not happened either in a subsequent case or in an application in this case. And so the reason I don't come here before my lords and say they should be paying it all is for that reason, and that's an important reason because this is a discretionary matter, not easy to disturb on appeal. But secondly, that actually what you see when you look at the case law is reference to the balance that has to be conducted. It comes in often in whether or not you make an order at all, in the proportionality and the effect on the freedom to conduct a business. But in all cases, we're talking about a balance between the effect on the ISP or other intermediary, and you see that the assumption in many of the CGEU cases are that there will be a cost to them and that will affect the way in which they can use their resources. And in my submission, that balance is not just a balance that you carry out on those particular facts. It is a balance that reflects the balance built into these directives. These directives are about striking that balance between enabling and facilitating the intermediaries to carry on their business, but also at the same time recognising the harm that this kind of environment can cause to intellectual property owners, and requiring the intermediaries to assist when they have specific knowledge.
A separate point that occurs to me, which I don't think would help your clients, but we may need to bear in mind if we're being asked to decide a point of general importance, is that there's quite a bit of emphasis placed, particularly in the Information Society Directive, on the importance of member states providing effective remedies, and in terms of Article 8.3, ensuring that right holders are in a position to apply for an injunction,
Exactly.
and so forth. Now, it occurs to me in a different context entirely, that of environmental law, costs as awarded in the UK have been seen as a barrier that was incompatible with EU law, and that necessitated the introduction of arrangements for protective costs orders. And I mean, one can see that there might be a similar argument run by an SME which was trying to protect its intellectual property rights. But unfortunately, it's not a point which your clients, I think, could argue.
Well, that's not right, actually, my lord. It's a good point, and I am entitled to rely upon it, not because it would deter my clients, but because we're talking about what my friend says should be the ordinary order. And so it will apply to other smaller rights holders that, for instance, may be an individual filmmaker whose film is being pirated massively on the internet. Consider somebody like that. And my lord is absolutely right in that having an order whereby you have to pay them to police the sites that are being used to illegally stream your film, costs that you can't control yourself, as I've emphasised, is potentially a problem where it has to be an effective remedy. So my lord is right that I can't say that it would have the impact on my clients, but I can say it will have an impact on some rights holders who are entitled to seek orders under these provisions. Now, my lord, I see I'm really nowhere near where I wanted to be in my notes, so if I could move on to just say a little bit about the CJEU cases, and then I'm going to very quickly explain to my lords why the analogy with Norwich Pharmacal was a complete sideshow. It's not the juridical basis upon which these orders are based. The CJEU cases are consistent with my case in my submission, and it's not just one that happened to be a reference from Austria. It's case after case where one sees an inbuilt assumption that what's contemplated is an order that will require the intermediary to use some of its resources which otherwise it would be able to devote to its business as it saw fit. And in fact, we even see an emphasis sometimes on that the orders have to allow intermediaries a freedom as to how it arranges its resources to comply. Now, that's important. In this case, it's done by pre-negotiating Schedule 2, that in our instance. But why it's important is that it is contemplating that intermediaries will bear the costs, and it's up to them to a certain extent with what they do. And in a sense, the dispute that we have here about monitoring the monitoring goes away when you look at it like that, because they say, well, that's what we want to do. And if you approach it in the way the European cases do, it doesn't matter, because we say it should be done more efficiently, but if they want to do it like that and it's the cost to them, then that's fine. So let me turn up some of the cases to look at briefly. The first two are L'Oréal and UPC. I can do L'Oréal by reference to the Court of Appeal judgment. And can we pick it up at the point that we, in fact, just left Lord Justice Kitchen? So that's page 246, paragraph 145. You see a passage set out there by Lord Justice Kitchen. And it's directed to the fact that you couldn't have a general monitoring obligation, not just because it's prohibited by Article 15 of the E-Commerce Directive, but also because it would be excessively costly. And one of the provisions in the Enforcement Directive is Article 3, for your Lords, for my note, says that that's not allowed. So you see what Lord Justice Kitchen is pointing out is that the court, the CJEU, is contemplating that the cost would be borne by the intermediary. And he says, if you skip forward to 147, both these cases, so that includes what he's saying about L'Oréal, support the fact that the court is contemplating that the intermediary would bear the costs of implementation. UPC is the other one that he's referring to there, which my friend took you to briefly this morning. And that is one which specifically is directed to the freedom to operate a business that I've just foreshadowed. So if you go, if you can, to Authorities Bundle 1B, tab 32. I'll take this quickly because my friend showed it to you. As I think you saw this morning, it's making available infringing copies of films, the website, to be blocked. And if you go forward to 49, which is, I think my friend took you to 43 and then down to 50. 49 introduced the freedom to conduct business. And of course, that is one of the fundamental freedoms in the Charter, and that's why we're in a balancing exercise. And paragraph 50 is the point being made about the blocking injunction will restrict the free use of resources at his disposal, which is said to be part of the freedom to conduct a business. And it's expressly contemplated again that the intermediary will be required to take measures which may represent a cost. And the point that I just foreshadowed is actually in this case, if you go forward to 52, this is the one, the emphasis about the intermediary having freedom to choose how to comply. So what is envisaged by the CJEU is that the intermediary will have a right, which is part of the balance, to conduct a business, which means his resources shouldn't be unduly fettered. And even when the order's made, he should have a choice as to how to comply. But what's contemplated is the order may well have an effect that requires him to incur a cost. And we see the same in my submission in the two cases my friend suggested in her case, but did not go to today. I think that's right. She said they supported her, but they don't. They're Scarlett and Netlog. Scarlett is in tab 28 of the same authorities bundle. It's page 1054 of the electronic bundle, and it's another case against an ISP. It was brought to seek to prevent infringement in sound recordings. You see that in paragraphs 15 to 16. So that's 1065 and 1066. However, the application was rather ambitious. It was not to block access to particular locations on the internet. It was an attempt to require Scarlett to stop all its subscribers infringing copyright using peer-to-peer software. And that's the kind of software that enables file sharing over the internet. And apparently it was assessed technically by the court as something that was not entirely ruled out as feasible. Doesn't sound very promising. You see that in paragraph 22 of the judgment. And in fact, you see from paragraph 23 that at first instance in Belgium, the order was actually made. So if you skip forward to the operative part of the reasoning and pick it up at 47 on page 1074, you see that the understanding was that the effect of the order would have required a new filtering system to monitor all electronic communications made through the network.
Stopped the peer-to-peer exchange of out-of-copyright music.
Quite probably. I don't know how they were going to marry it up to what was in the catalogue, but I mean, it was the most extraordinary, ambitious application. And not surprisingly, it was held to be a serious infringement of the right to conduct a business and also a breach of Article 3.1 of the Enforcement Directive. That's the provision about not being unduly costly. And you see that at paragraph 48. So the conclusion at paragraph 49 is that it was not in accordance with the fair balance that's to be struck between the protection of IP and the freedom to conduct a business. Now, I rely on this. It's a case where the decision went the other way on the facts because it wasn't proportional and in accordance with the fair balance, but built into this is not an idea, as my friend suggests, that it failed because the ISPs were going to pay. It failed because what they were being asked to do would have been totally disproportionate, not in accordance with the balance for the right to conduct a business, not in accordance with the requirements and not to be overly costly, and also a flagrant breach of the requirement not to have general monitoring. Those were the reasons, but underlying it is the same contemplation that if it had been proportionate, they would have borne the proportionate costs. Now, Netlog is exactly the same. It's the same kind of application made by the same copyright body, but in that case it was against a social media type site. But it's exactly the same case, turning on exactly the same reasons, and it also supports my submission. The final case is the McFadden one, and that is a case about infringement of copyright in sound recordings. There, the intermediary was slightly unusual because it was a small business who was running a little Wi-Fi hotspot, and he was doing so to promote his business, and it was free, and there was no password, and it had been used by somebody else to infringe copyright. That is at tab 30. So 1087, a lot of it is devoted to the question of whether or not they are he was an intermediary subject to this at all. One of the issues was the ability to recover legal costs, and in particular the effect of Article 12. That's the immunity of acting as a conduit. And the court addressed two questions. First of all, if the claim had been for damages, and secondly, if the claim was just for injunctive relief. And the upshot is, not surprising, that the cost couldn't be claimed for a claim that wasn't allowed, but it was allowed for the claim for injunctive relief. And that you see at paragraph 75 on page 1098. That's where you couldn't get it for the claim that wasn't allowed. And paragraph 77 is where 76 to 78 is where it deals with the cost that was allowed. One of the reasons of taking you to this is not only does it have the same contemplation, but the way in which they characterise these types of claims is, in my submission, helpful. And it's the thing I foreshadowed earlier. Paragraph 77.
Point you made at paragraph 75. They can't recover, they can't claim reimbursement of the costs of giving formal notice because there isn't an underlying breach by virtue of Article 12. Is that the point being made?
No, that is it's dealing with two separate issues, this judgment.
But just looking at paragraph 75 for a moment.
Yes.
That seems to be the point being made there, that the reason that they can't be reimbursed the costs of giving formal notice is that the actual principal claim would have to be well-founded.
Yes.
It isn't because of Article 12.
Yes.
I mean, why does that not apply equally to other costs, like the costs of implementation after giving formal notice?
Well, for a start, because if you look at 70, the formal notice, I think, was the notice to require the service provider, notice to make sure...
That's the preliminary to an injunction application.
No. No. That's the point. 75 is the claim, is the notice and the claim for damages for infringement. It's my fault. I've taken it too quickly. It addressed two separate types of claim. 75 was the claim for damages, which is a bad claim. The remainder of down through 77 and 78 say that if your claim's different and it's for an injunction, you can get the costs. And the point I'm trying to make about the way they describe that second type of case, the intermediary injunction costs, is that what you're doing is applying either to a national authority or the court to have the service provider prevented from allowing the infringement to continue. That is very real as to what's going on. That is the guts of it in my submission. And that is reflected in my submission in what Mr. Justice Kitchen described as their role, Lord Justice Kitchen. So I'm back in the Court of Appeal judgment at para 56. Page 222. The ISPs are therefore inevitable and essential actors in those infringing activities. 4 lines down. And that's totally different to the type of situation of Norwich Pharmacal. And that's why I keep emphasising that it's their services that are being used to affect the infringement. And once they've been given specific knowledge, knowingly so. So what I do say that my lords get is the same overall picture of the contemplation that the intermediaries pay or bear their own costs in the CGA EU case law. We've also pointed out that the same broad approach can be seen across national case law. I specifically set out some of the French Supreme Court case in our closing.
The difficulty about that statement is, money launderers need banks, don't they? Criminals need banks. You get a Norwich Pharmacal order after the event, it could be said, well, the bank was an essential and inevitable actor in the money laundering that went on and shouldn't be indemnified in respect of its costs of disclosing the transactions. So the general principle I just slightly worried about.
What's slightly different here, my lord, is that it's the fact that this increase in the ability to infringe online requires intermediaries. That's what it's about. And it may not be one individual intermediary. It may be said, well, if it's not me, it'd be somebody else. But we're looking at them as a class, and it's the massive damage that it caused, both socially but also economically, to the rights holders. I don't shy away from that. We are much worse off because of the ability to infringe on a much larger scale than happened before. And that's what it's about. The central act in this much worsening of the situation for rights holders. Now,
Can I ask you this? Looking at Scarlett, and particularly Scarlett, also L'Oreal, the court relied on Article 3.1 of the Enforcement Directive.
yes.
And 3.2. And that was in relation to an ISP. Is the implication of that that the regime governing in the grant of injunctions against ISPs under the Enforcement Directive is not, in fact, exclusively governed by national law?
No, it's not.
Yeah.
Right. The Enforcement Directive is part of our law.
Yeah. And therefore, in terms of Article 3.1, remedies are to be fair and equitable. And in 3.2, also effective, proportionate and dissuasive.
That is now the mantra of national law throughout Europe on enforcement of intellectual property rights. My Lord has a good point.
Yeah. Yes. And that presumably would apply to the conditions attached to the remedies in relation to costs as much as anything else.
Indeed, and that's why you see in the judgments that we've been looking at, Article 3.1 crops up again and again.
Yeah.
Because a reason for saying you can't have that order is because it's too costly, and it's because it's too costly to the ISP or the intermediary.
Yeah.
Now, the additional thing that I wanted to make sure that you'd seen, which I think at least my Lord Reed had seen in the French case, is that they view what's going on as requiring properly, they say, the intermediary to help in the combat against. They have a contribution to the fight, the intellectual property infringement fight. So if we could turn that up very quickly. It's tab 33 in Authorities Bundle 1B. No, it's not.
Yes,
It is.
it is.
It is.
By Supreme Court of Appeal, we mean the Court of Cassation.
Exactly, yes.
Yes.
And you've got an extract which makes it absolutely clear that their view is that the costs of complying should be borne by the intermediary. But the passage that we didn't set out, and which in my submission is important, is the one bridging 1128 and 1129. Because it's an exercise in interpreting the directives. And it says, in light of this, the text must be interpreted, providing...
Which page are we looking at?
1128 at the bottom.
At the beginning, however.
Yeah, but I'm picking it up right at the bottom. Penultimate sent 2 lines up from the bottom. So it mentions the directive 2031, 2001-29. In the light of which this text must be interpreted, providing that notwithstanding their exclusion from liability by principle, that's the exclusions, access and hosting providers, that's the 2 types covered by those articles, are obliged to contribute to combating unlawful content. And in particular, the infringement to copyright and related rights, given that they are best placed to put an end to such infringements.
The next, what's the reasoning in the next paragraph? Said intermediaries contribute to the defence of the interests of the rights holders, which are of a private nature, then such that neither the principle of the equality of citizens in relation to public expenditure nor the criteria arising from said principle adopted by the
Yes, it's rejecting a defence by the ISP based on the principle of equality, equal sharing of public burdens.
Yeah, exactly.
Égalité devant les charges publiques.
That looks like a specific principle of French law.
Well, they're rejecting the argument that this is a burden being borne in the public interest, and therefore it should be equally shared. They're saying, no, it's not the general public who are benefiting, it's the right holders, so it's of a private nature.
Why that should
what
be
we
thought
might
to
say.
reinforce the proposition made in the previous paragraph.
It's not. It's dealing with an argument being put forward by the ISP. They're saying this is all a public law matter, and therefore we shouldn't be...
We should be in the Conseil d'État.
Yeah, exactly. Yes, it's an administrative law principle being relied on by the
I think
ISP.
your opponent would say it's a private law matter, and that's exactly why the ISPs shouldn't have to pay. They don't seem to address that argument here.
What they have done is look at what the directives are doing, and what I rely upon is what the directives, those two directives, are doing in requiring them to contribute to the combat.
Yeah.
Now that is in answer to an argument which may not be the one that's being advanced by my friend, but it's their take on the effect of the directives. Now, my lords, very briefly before I sit down, the analogy that they say is relied upon is not the foundation of the order that's made. You have to understand the argument that was being run before the judge, and that's that, first of all, that there was no jurisdiction conferred by Section 37 at all, but then there was a fallback position that there had to be a pre-existing duty, and that's why the argument that was put forward by reference to Lord Justice Buckley's judgment. It's all about saying that Section 37 required a pre-existing duty, and the judge rejected both of those submissions, and the actual ratio is relying upon Furry and LaRue, saying that there's an unlimited power and that new categories can come along. And so you see that in 104 of Mr. Justice Arnold's judgment. I think it's 104.
So
They said the jurisdiction isn't limited to defined categories.
Exactly, and the only point about the analogy would have been that if that had been right, he might have been minded to say that he would extend it by analogy because of the Lord Justice Buckley dicta. It's quite plain that the ratio of his decision is 104, the second half, when he says that Broadmoor and Furry are the right answer, and you get that also in Lord Justice Kitchen, where he says that it's broad power, and then goes on and decides that the principled basis for exercising the broad power is Article 11 of the Enforcement Directive. It's not an extension of Norwich Pharmacal. There is, of course, a similarity as far as it goes, which is the way Mr. Justice Arnold put it, in that they are not tortfeasors, but there are big differences as well. There are big differences because of the central position. Their innocence is different. Their innocence is different because they have specific knowledge of their service being used in the future to infringe. That it's directed to the future. And the purpose and policy underlying the orders are different. The purpose and policy is reflected in the EU materials that I've taken you to. And it is the foundation, the EU materials, whether the order is a copyright order or a trademark order. It's the same thing. You've seen it first implemented in the Information Society Directive, but secondly extended in the Enforcement Directive. So, my Lord, there are a series of policy points that we've answered in our case as well, but in my submission they don't take the matter any further forward. The final point that I want to make is that the costs of the litigation, they truly are the exercise of a discretion specific to the facts which the judge took into account the fact that they weren't a tortfeasor, but also the fact that they were fighting vociferously to resist the relief, and they lost. He also took into account the different nature of the relief, the whole load of factors that are in the short judgment on costs.
I'm not sure we heard any substantial arguments
No,
about
they
these.
were allied together. I think my friend is hoping that if she can persuade you on the implementation costs, they can just swing in behind. She never addressed any submission attacking the exercise of discretion.
Seems to me to be highly questionable whether the order granting leave actually envisaged that that issue would arise at all.
My submission
I
is
agree
it
the
doesn't.
language is a bit ambiguous, but
Doesn't.
I don't believe that was the intention.
No, I agree with that. Is there anything else that I can assist you with?
No, thank you very much. You've, I think, kept within your expanded time. If we sit till, or are ready to sit till 5 past, Mr. Brandreth? Yes, Ms. May.
Thank you, my lords. I'll take the issues as briefly as I can. First and foremost, our position is that the injunctions in issue in this case are there to protect the private property rights of the respondent and to improve its profit margin. It is for the benefit of the right holder, and it is therefore the right holder who should absorb the costs in respect of the injunction in terms of its implementation. It's open to the right holder to try and seek recompense against the wrongdoer if that's what they choose to do. It's much fairer for each applicant to bear the costs of his injunction rather than for the ISPs or other intermediaries to shoulder the costs burden of all of them. And just as my lords will have seen over the years in respect of Morava injunctions and bankers' trust type orders, one sees time and again in those kind of scenarios, it's the same banks who are on the receiving end of those injunctions and orders. So too here, over time, it'll be the same internet service providers who are the respondents to these orders time and again. And it's simply not fair for them to shoulder the cost burden in respect of applicants' private property rights. The respondents in this case argue that the ISP service is being used to infringe. Now, that's a submission which needs some care. Firstly, the third-party websites, the target websites, which are the subject of the injunction, have absolutely nothing to do with the internet service providers. It is those websites that are undertaking acts of infringement.
And you say there aren't even contracts, is that right, with them
There is
necessarily?
no contractual or other relationship as between the internet service provider on the one hand and the target website on the other.
Contractual relations are with the subscriber and with the advertisers who basically fund it.
Indeed.
And that's it.
That's it. The internet service provider's role is one of facilitation only. And it's the same kind of facilitation that was in the contemplation of the House of Lords in Norwich Pharmacal and other kinds of cases where the court has recognised a situation where an innocent party is mixed up in a wrongdoing, facilitates that wrongdoing, but isn't themselves a tortfeasor. So one can't distinguish the internet service providers from those other kind of innocent parties. One cannot say that the ISPs are a central actor to the wrongdoing in a way that customs and excise were not, for example, in the Norwich Pharmacal situation, or in the way that the website operator in the Totalize case wasn't. They are all equal players in terms of facilitating a wrongdoing, but they are all equally innocent in respect of that wrongdoing because they themselves are not tortfeasors. And just as my Lord Mance pointed out, banks, another example. they may be said to be mixed up in the wrongdoing in terms of money laundering or other forms of fraud. They are at the heart of facilitating that wrongdoing. They themselves are not wrongdoers, and they are never on the receiving end of an order whereby they are also obliged to comply with the costs of that order. Why put the internet service providers in a different position?
Can you just help us on the costs? I mean, I get the impression that wasn't really focused on, but a specific criticism has been made, namely that you're seeking to monitor, recover costs of monitoring which is supposed under the orders to be done by the applicants for an order. What do you say to that, and what are these costs, really? You're only seeking the marginal costs, you're not seeking the capital costs.
Absolutely, we're not
So
seeking...
what are the costs you're actually seeking?
So we're not seeking the capital costs, we're only seeking the marginal costs. The absolute figures, the precise figures are confidential. They're set out in the confidential annex to the Statement of Facts. They arise because of the requirement on the part of the internet service providers to implement the blocking orders and to check that the implementation is properly carried out. And that's necessary to avoid the problem I referred to this morning, which is known as overblocking. So a good example of when an overblocking situation can arise is when 2 or more websites are all hosted on the same IP address. One of them might be one of the target websites in issue, another might be the Radio Times. And this happened in a previous copyright case, and the information, again, is in the Statement of Facts and Issues. In one of the previous copyright cases, the ISPs inadvertently blocked access to the Radio Times website because it was on the same website as one of the infringing websites. In that case, it was same IP address.
On the same website?
On the same IP address.
IP address.
Sorry, I misspoke.
Yes.
Sorry.
Because it was using the same server, host server.
Yes, and that was an example of the applicant's checking process failing and the ISPs then inadvertently blocking access to a lawful website, which of course obviously caused ramifications.
In paragraph 199 of your printed case, which is what Mr. Speck drew our attention to, you say the respondent has no incentive, this is under the law as stated by the Court of Appeal, to invest in verification, testing and monitoring. Now, are you referring there to investment in the sense of some capital equipment or software required to do this, or are you referring to what one might loosely call revenue costs of monitoring, or are you referring to both?
What we're referring there is to a general respondent. One has to look back to the previous paragraph, to this concept of the innocent respondent. So it's a general respondent, it's not my clients in particular. And it's making the observation that a general respondent may not have the incentive to invest in verification techniques without proper costs protection.
The point that was made by reference to this paragraph by Mr. Speck was that what we're really arguing about in money terms is the cost of verification, testing and monitoring. Is that true?
Yes, it's the implementation costs of the order.
Well, the implementation costs of the order are not necessarily the same as verification, testing and monitoring. There may be some costs, possibly relatively small, associated with actually complying with the injunction. And there may be further costs incurred in monitoring so as to ensure that it really is within the injunction, as opposed to leaving it entirely to them to do it.
Yes.
Now, conceptually, those are two different kinds of costs. Are you saying that the first type, pure implementation of the order, is financially trivial, and it's the second type that matters financially?
No.
Will we get the answer to this by looking at the confidential annex?
Yes.
Right, well, in that case, in due course, we'll do that, no doubt.
That's in...
We can find, it's an annexure to the SCI, isn't it?
Yes, it is. It's page 58.
Yeah.
But I don't think even in that annex the separate costs of testing and monitoring are broken down. From my client's perspective, it's all part of the same process of implementation. Can I just row back for a moment just to make sure that there's no confusion? From my client's perspective, they undertake a process of monitoring and checking to ensure that there is no overblocking. They say that is a perfectly reasonable approach to undertake to protect their own commercial position. All that they are entitled by reference to...
Those are revenue costs, are they?
No, these are the costs incurred in respect of implementing these injunctions.
Just looking at the confidential appendix and without
Yes.
reading it,
Yes.
we go to pages 14, 15, 16. Am I right? It's just the first two items on page 15. Costs of complying with website blocking injunctions, and then costs of processing and costs of implementing.
Yes, indeed.
Is it just those, nothing else?
Indeed.
I mean, costs of upgrading is a different thing. That's a capital.
One has to separate out... yes, it's the cost of complying on page 15.
Top two boxes.
Top two boxes, isn't it?
Yes, the top two.
Nothing else.
Yes.
But how does that tie in with 199?
So 199 was making a broader point. Paragraph 199 has been misunderstood and mischaracterized. It's not a point about my clients, it's a more general observation about other potential internet service providers or other innocent respondents on the end of one of these kinds of applications.
So you're making no claim in respect of the entries in 199?
Well, this is the point I'm making about the difference between capital and revenue costs. The bottom box on page 15 is concerned with what one could loosely call capital costs. It's the upgrading of the system as opposed to the increase in the day-to-day costs of managing it in terms of manpower, electricity or what have you. And as I understand what you've just said, you are claiming the top two boxes, which are of a revenue nature, but not the bottom cost box, which is of a capital nature.
That's exactly right, my lord. Yes, yes. And one of the things that's said against us is that those costs are somehow unreasonable, that
No finding to that effect.
there is no finding to that effect. In fact, to the contrary, there is a finding at paragraph 250 of Mr. Justice Arnold's decision at first instance, which my lords find on page...
Paragraph?
250, on page 360. Where the judge records the evidence of future implementation costs and says, I see no reason to think that these are anything other than genuine estimates.
This is 250.
250, yes. And with respect, it's a commercial nonsense to suggest that my clients would be incurring more costs than are necessary to comply with these injunctions, bearing in mind that the status quo is that they don't recover those costs at all. And of course, in any event, the fallback is that, as we see from the authorities, all they're entitled to is their reasonable costs of compliance. And so if and to the extent in a future case there is an issue about what the level of that reasonableness should be, that is a factual dispute to take place before a trial judge. It doesn't in any way undermine the principle that we urge before my lords in this case. And just as with banks and moreover injunctions and bankers' trusts, there isn't a minute analysis of the reasonableness of the costs that those banks incur in respect of those injunctions. It's taken as read that they are entitled to be reimbursed in respect of the implementation costs. Those costs are reasonable. And indeed, it's often stated specifically in the undertaking that it's the reasonable costs that will be recovered. And no one requires automation on the part of banks. They're entitled to undertake the exercise which they do in compliance with those orders in the way that they see fit. So too with my clients and any other respondent as an intermediary on the receiving end of one of these kinds of injunctions. The way we see the case could be phrased as follows. Why should the court impose a burden on an innocent party, like my clients, that it would not, in law, be under any duty to bear in the absence of the order? And as we've explained this morning, we say it is an established principle that one of the conditions of the order, because it's an order made against an innocent party, is that the innocent party should be recompensed for any costs and damages incurred in respect of implementation. Reasonable costs. My friend makes the attempt to try and single out internet service providers for some kind of excessive punishment on the basis that they are not truly innocent in the way that other wrongdoers might be. But as I submitted this morning, innocent means not a tortfeasor, not a wrongdoer. There's no dispute here. My clients are not tortfeasors. And the level of knowledge is just the same as in these other cases, and it arises on having been given notice in respect of the application. One of the points my friend raised this morning...
This is whether you're relying on the safe harbours or not. I know you say you're not.
Yes, indeed. Well,
you're plainly right about that in the case of trademark infringement.
yes.
But the result, the position would be different in relation to some other intellectual property rights.
Yes.
We don't accept that the position would be different in respect of any other
Well, no,
intellectual
but on that limited point, I mean,
You need to
there
rely
are
on the safe
circumstances.
harbours.
There are some circumstances which you would need to rely on the safe harbours. For example, where it was an infringement because you had provided a machinery for selling on the internet itself.
If that was the particular factual scenario for that particular intermediary.
Yes. And I agree, I appreciate that doesn't arise with trademark infringement,
Yes.
but it might arise with other rights. Might it not?
Yes, I mean, there's a risk that with the scenario my lord poses, the party wouldn't be an intermediary and they might be a primary wrongdoer.
Exactly, so they would need safe haven provision.
Well, in that scenario, they may not be able to rely on the safe harbour because they're not necessarily an intermediary. They're a direct supplier of an infringing
No,
product.
because if you simply provide facilities on your website by which you can pay directly to a bank or a credit card, you wouldn't get anything to do. Well, if the mere fact of having a website, of hosting a website, or of giving access to a website on which it is possible to pay for goods and conclude a contract, that might in some circumstances constitute an infringement apart from the safe haven provisions, or is that wrong?
We can't conceive of a situation in respect of an internet service provider, a mere conduit, where they would ever be liable for an intellectual property infringement.
A hoster might?
A host might, but it would depend on the particular facts and circumstances. One of the points that my friend raised in his submissions was the issue of discretion. And I just wanted to grapple with that very quickly.
Better be extremely quick.
Yes. Oh, gosh, I didn't see the time. What we say in respect of discretion is that, of course, injunctions are equitable remedies and they are an exercise of the court's discretion. Whilst the court may have a virtually unlimited power to grant injunctions, that power must be exercised in accordance with principle. And that principle shouldn't be jettisoned simply because the power to grant the injunction is being exercised in a new way. Similarly, in respect of the question of proportionality, it is necessary to deal with proportionality under Article 3 of the Enforcement Directive, but it's important to understand that the question of proportionality under Article 3 doesn't carry within it inherently the answer to the question of where the cost allocation should fall. It says nothing one way or the other about the costs burden. The point of proportionality in the EU context is that it's a final check on the injunction, but it doesn't determine the conditions and procedures which are a matter of national law. The logically anterior question to the question of proportionality is the question of who should pay. That is an anterior question, and we say that that question is addressed by reference to the national law principles we've relied on before, my lords. Finally, just two short points. In respect of the Court of Justice cases, as we submitted this morning, my lords don't get any real assistance out of those cases because, number one, they don't grapple directly with the issue before my lords today. Number two, they do nothing more than recite Article 3 and the requirements there, and to the extent necessary, where they make an assumption in respect of costs, it's based on national law. Finally, in respect of legal costs, we do include an argument on legal costs in our written case. We do urge upon my lords the principles enunciated in the totalised decision in respect of legal costs, which we say apply with equal force to an innocent party like my clients. And that includes the costs of the action and the costs before the Court of Appeal. And in our submission, if our arguments in respect of legal costs succeed, then the orders will be varied in respect of all internet service providers who are the subject of this action. It's not a situation where there can be one rule for one internet service provider and another rule for another within the context of this action. If my lords accept our submissions on legal costs, it's necessary that the decision on legal costs was wrong and it must fall away.
Thank you very much.
Thank you, my lords.
The Court's grateful for the submissions of counsel in this interesting case, and will have to take time to consider its decision, which will be handed down in the usual way. Court's adjourned.